A very good afternoon to you. Thank you so much for joining us here on Nationwide at 5 this Monday afternoon. It's time for the cover story. I'm Ricardo Brooks.
And my name is Sanjay Lewis. Good afternoon, Ricardo, and good afternoon to our listeners.
Good afternoon, Sanjay. Listeners, we hope we find you well. We hope you weren't too badly affected by today's squall line. Every day I learn a new weather term. I never heard of a squall line.
Never heard that one before.
Yeah. In the cover story this afternoon, the Governor General, Sir Patrick Allen, has made recommendations to the Joint Select Committee that's reviewing the Integrity Commission Act. According to the report in one of the nation's daily newspapers, Sir Patrick expressed concern about some of the Commission's processes.
This includes the process of appointing temporary staff being the same as the process to appoint permanent staff. He also reportedly took issue with the ambiguity in leadership authority at the Commission. According to the article, Sir Patrick is suggesting that lawmakers create regulations under the Integrity Commission Act to clarify the processes of appointment. Well, joining us for discussion this evening, we have with us Attorney at Law Shane Dallin and also Attorney at Law Kenyatta Powell. Gentlemen, good afternoon.
Good afternoon, gentlemen. Listeners, the suggestion, the report rather, that the Governor General had made recommendations to a parliamentary committee raised some eyebrows with some questioning whether it was inappropriate for the representative of the monarch to be having a say in the legislative process. So these two attorneys will help us give us their views. Good afternoon, gents.
Good afternoon to you.
Kenyatta.
Good afternoon. Good afternoon, Sanjay and Ricardo. Good afternoon to your listeners.
Good afternoon. Shane Darling, let me start with you. Your reaction to the report?
There's validity in some of what the Governor General is saying. I've looked at it, and I've looked at the legislation, and I do find some validity in what he's saying.
Mm-hmm. And Kenyatta Powell, your initial reaction?
My initial reaction is that it was absolutely inappropriate for the Governor General to be intervening in the legislative process in this way. It's not at all part of his constitutional role. And beyond that, I found the substance of what was in the intervention to be curious at best.
So Shane, let me try to separate the two things, because you say that there is merit on the substance of what he has recommended. So let's start with the substance.
Okay.
What about the recommendations? Let's start with the one, for example, ambiguity in leadership authority. Did you find that it met the substantive mark?
Okay. So the first thing is that the structure of the Integrity Commission, as stated by the Governor General in the letter to Parliament, creates silos. What is meant by that is that you have an executive director of the Integrity Commission that operates in silo from the other directors. So there are 4 other directors. Those 4 directors do not report to the executive director, but they report directly to the commission, similar to the executive directors. So it's a system like a CEO. You have a head of entity reporting to a board, but then you have the directors for that same entity reporting directly to the board. It creates a silo, so the executive director cannot really control the processes below him, because the directors who are supposed to be reporting to him are reporting to the same boss that he is reporting to. So it creates a little conundrum there in terms of good administration and good governance when you have a system like that. So there is a little conundrum there, and I really don't see the rationale for it in that way.
Kenyatta, that sounds reasonable. Why would you say you find the recommendations curious?
Because I just don't see the point. I don't see the point that is being made. As I understand it, the structure of the Integrity Commission, and specifically the structure in relation to the various divisions and the directors that head those various divisions, is that you are supposed to actually have that kind of a separation in which
for instance, the division dealing with investigation is supposed to be that director, head of that division, and the people in that division are supposed to be doing their work in a sort of, I suppose you said, independent or semi-independent manner, so that once they have done their work, and then, for instance, passes it over to the division dealing with corruption prosecution, it would be for that director and that division to then bring their own independent judgment to the same matter. So so you may have an investigation. Certain evidence may have been gathered, etc., and it's passed over to the division dealing with corruption prosecution, and that division may, applying its own independent judgment, come to the conclusion that, for whatever reason, there's nothing here to recommend a prosecution. The whole thing sounds to me like much ado about nothing.
But counsel, let me, if I may, in a
Yes, go ahead,
situation
Shane.
like that, you could have maladministration, where directors are allowed to do what they want to do, and the head of the entity, who is the executive director, has no control over that process in the way in which it is set up now. So the director is going directly to the commission, which is what you refer to as the board of the Integrity Commission, and so to the executive director. So what you may find, gentlemen, is a situation where the executive director, who is the head of the entity, is learning about something only when it gets to the commission, or if the commission should say to him. Although all the staff who are the directors report to him, regardless whether administratively, functionally, or operationally, you'll find an administrative issue there.
That sounds like
That's a valid point, wouldn't you say?
No, but that sounds like entirely a leap to me, because the fact that they are not reporting, quote unquote, to the executive director doesn't mean that the executive director somehow can't know or can't have the information as to what is happening.
But doesn't that assume, Kenyatta, that the directors would be inclined to share the information? Because what if you have a director who decides, I don't report to you, the law doesn't require me to share anything with you, and therefore I won't? Wouldn't it be good if it were clear that the executive director, as head of entity, should have knowledge of what's happening in the entity?
And again, I say, to what end?
For the proper governing of the body.
I remain. Here's the thing. I take the point, but I remain unconvinced. I remain unconvinced that this is something that anyone should detain themselves about.
But Kenyatta, if the executive director has the role of overseeing the daily operation, just as what Ricardo just indicated, wouldn't it be for good governance within the organization that there's a clear line of communication, there's a clear line of reporting, and the executive director is controlling the overall operation?
I still think it's much ado about nothing.
Well, what it does, gentlemen, Section 29 tells you that the executive director is responsible for the day-to-day management of the entity. How can he truly be responsible for the day-to-day management of the entity if the four directors who are appointed reporting directly to the commission? How can he really be held responsible for the overall operation and the day-to-day management if that is the situation? I believe that is a point that should be addressed. Yes. So nothing is wrong with the comment or the suggestion that we addressed.
Yeah. There's another question, though, Shane Darling, as to whether the recommendation ought properly to come from the Governor General. Because I see concerns being raised about his constitutional role and whether he ought to insert himself into what has now become a politically charged issue. How do you see that?
Well, let me say that it is unusual for Governor General to make comments relating to the legislative process, given that the Governor General does have a role in terms of a final role in the assenting of the legislation. But the Governor General has a role in terms of the administration of the Integrity Commission. Remember that under the Integrity Commission Act, any complaint about the executive director or any director regarding discipline, it is the Governor General who would have to act in terms of commissioning a panel to look into what we call misbehavior in relation to the Integrity Commission members. Now, so the Governor General, as an overall administrator in that process, would be concerned that there may be issues or gaps that would exist in him carrying out his functions if there are silos operating. So, for example, a complaint may come to the Governor General. Usually, it would come through the executive director regarding any staff member, for example, one of the directors. What you're finding is that the executive director may not be able to give account of what the complaint is. And therefore, the Governor General is pointing out some issues that may affect his whole operation in terms of his function under the Act. Nothing is wrong with that in relation to that. But as I said, it is unusual, but nothing is strange.
We're up on a break. After the break, I want to hear you two gentlemen on whether that isn't exactly the problem, that we have this strange system of government where we're supposed to have a constitutional monarch who is supposed to be set aside from the issues, yet we vest executive power in that monarch. And as I listened to Shane Darling Kenyatta Powell, I thought, isn't that exactly the problem? That we have created this sort of hybrid creature where he's vested with executive authority acting on behalf of the monarch, but the convention says he ought not properly to interfere in these matters. Can the two things reside in the same body or the same office properly?
Well, let me first address something that Council said, and it will lead into my general point. I don't think that the Governor General being vested with certain authority in terms of receiving complaints and taking disciplinary action in relation to officers of the Integrity Commission means that somehow gives the Governor General whose functions, right, are tightly prescribed in the Constitution. That doesn't mean the Governor General is somehow then at liberty to be inserting himself, because this is what he has done, inserted himself by his office in the part of the legislative process, right? That the Constitution gives him absolutely no authority at all. The Governor General's sole authority in relation to legislation has to do with what comes at the end. And I believe the relevant section is section 60, subsection 3 of the Constitution, which says that after a bill has been passed in the manner prescribed in the Constitution, the Governor General shall indicate if he assents in the monarch's name or if he does not. And that comes at the very and that comes at the very end of the legislative process. So for me, I don't just find the intervention unusual, and it is. I find it to be offensive in the extreme, because we are talking about the local representative of a foreign non-Jamaican monarch. And I think that it is right and proper that such a person must remain tightly within his or her constitutional limits. And those limits are that where specific legislation does not confer a discretion on the Governor General to act in his or her own stead, the Governor General exercising executive authority on behalf of, again, our non-Jamaican foreign monarch, can only do so upon the advice or recommendation, etc., of either the Prime Minister, the Minister's Cabinet, some commission, etc. And the Constitution is pretty clear about this, I believe. So you can find that around Section 32, I believe, of the Constitution that outlines how the Governor General is to exercise his executive power. He's exercising on behalf of the monarch. So that yes, Ricardo. Yes, Ricardo. What I would say is this, and this is something I have said publicly before. A lot of our constitutional arrangements have absurdity written into them, right? Because we are a modern, we claim to be a modern independent country, mostly populated by the descendants of enslaved Africans, yet our head of state is an Anglo-German British monarch. That's crazy.
I want Shane Dallin to pick up on a point that Kenyatta just raised, the structures which govern how the Governor General should act. It's very clear. Could this move by the Governor General be viewed as a breach of the expected neutrality of the office of which he holds?
Okay, let me be clear on it. So the point that Council made, when you're looking at the Constitution, you can't stop there. You have to go further. Because the Constitution also tells you that Parliament can make laws in keeping with the Constitution, as long as it does not violate the Constitution. Now, so the Parliament made laws giving the Governor General certain responsibilities. So, for example, I'm sticking with the Integrity Commission Act here. The Act gives the Governor General the power to appoint directors and the executive director of the Integrity Commission. The Governor General raises the point that he became aware of one acting appointment of a director through letters from Parliament. And it is in the legislation that the Governor General has the power to make appointment as well as acting appointment, save and except under Section 30, subsection 8 of the Integrity Commission Act, where the appointment is the acting appointment is being made only for 3 months. Anything outside of 3 months, it is the Governor General's role to appoint somebody acting. Now, the Governor General is saying there is something awkward in this because subsection 30, subsection 8 runs counter to Section 35, 36 of the Interpretation Act that states that he who has the power to appoint has the power to make acting appointment also. So Section 30, subsection 8 of the Integrity Commission Act gives a specific acting appointment, but only for 3 months. It is untidy because after the 3 months acting appointment of Mr. Lawrence, it is the Governor General who must now step in to make further acting appointment. And what
but Shane Dallin, isn't it the case though? Shane Dallin, just stick a pin right there, because the Governor General does not act independently when appointing persons to the commission. So
No.
And if he does not act, someone is recommended to him and he does the appointment. Isn't that his ceremonial role that he's performing?
Yes, but I don't think that's what the Governor General is objecting to. The Governor General is saying that the arrangements are untidy in how we are doing it, and it is correct. It is either you're going to give the Commission the power deliberately to appoint a person acting when there's a vacancy, or you're going to
which is what Section 30, subsection 8 does.
No, but what I'm saying to you, Section
it gives it
30, subsection.
No man.
Hold on. Let Shane finish the point and he communicate.
What I'm saying to you is that what he's pointing out is the untidy nature of it. What I'm saying, Section 30, subsection 8 gives the Integrity Commission the power to appoint without the Governor General's involvement an acting person, but only for 3 months. If it goes over 1 day than the 3 months, the Governor General has to come in. So what we are saying here is either you leave it to the Governor General to make the acting appointment, which would go on until the vacancy is filled, or you give the Integrity Commission that power to appoint someone acting until the vacancy is filled. What you have is a limited appointment under Section 30, subsection 8 for 3 months, and then you revert back to Governor General That's what they're pointing out here.
Kenyatta?
No. Again. And I said this before. Seems that much ado about nothing. And I'll tell you why. It is clear, and whenever I hear counsel say that something is untidy, I don't know what that means in terms of law and legalities. No, hold on. No, man, I don't know what that means let me finish. Don't know what that means in terms of questions about legality. So, it is clear that what Section 30 subsection 8 is, right, is to give the Commission a specific power to make an acting appointment for a limited period of time, i.e. 3 months, 90 days. I am not sure why it is that should be a problem. Not sure why that should be a problem, except that counsel says it's untidy, and he says it's untidy because if it goes over for more than a day over the 90 days, then the Governor General has to step in. But even that formulation is not quite true, because again, in terms of the appointment of the directors, the Governor General does not have an independent authority to act. He must act on the recommendation of the Commission. So that, again, I am not sure what that discussion is. I'm not sure what that discussion is about.
Yes, but
hold on. Let me finish, counsel. Or what it is meant to accomplish. As far as I'm concerned, it seems perfectly reasonable. It seems perfectly reasonable to me that Parliament creates this lex specialis of Section 30, subsection 8, and gives the Commission the power to fill a vacancy. And to fill that vacancy for a limited period of time.
Let's just hear. Let's give Shane Darling the last point.
Running out of time, Shane Darling.
Let me show you why I say it's inappropriate and untidy and for good administration. In relation to the executive director, they said legislation does not give the Commission that power to appoint someone in the acting post for executive director. Hold on, no. Counsel, just hold on. No, that's what we're pointing out. If you're going to have a system that is running smoothly, this upscotching around the process is untidy. And I'm saying to you, in relation to a director, it gives the Commission the power for a 3-month acting appointment and reverse to the Governor General on the recommendation, of course, of the Commission after 3 months. In relation to the executive director's vacancy, it is directly to the Governor General that the Commission must go immediately for an acting appointment. And so what they're pointing out is that it could go very smooth in terms of setting up the legislation in a structured manner in which the operations of the entity is not disrupted by this untidy nature and the confusion that takes place.
Yeah.
There's no confusion.
Gentlemen, we are out of time.
For acting appointments dealing with the directors and the executive director. It seems perfectly logical to me for those all over the place.
We're out of time. Shane Darling, Kenyatta Powell, thank you so much. We should tell the listeners, it doesn't appear the Parliamentary Committee took up the Governor General's recommendations. I watched both days and I actually did not hear them deal with those recommendations from His Excellency. Gentlemen, thank you so much. I appreciate your time.
You're welcome. Yeah.